Looks like we are ready to get started. Just a couple of things before we get going too much. This year, this is a little bit different than how we've done orientations in the past. Acknowledging that there's no way that we can cover everything that we would typically do in an orientation in 3 hours. There's some other hopes that I'd had for you all, but the timing was really, really right to be able to do this tonight, as once in a blue moon, a really magical thing happens in a month, which is there's 5 Tuesdays, which allows us to be able to have Jeff Parker here, which is fantastic. There are other things that I would like to be able to help to show you. Some tours of our town facilities, etc. Most of you have been around quite a bit and are pretty familiar with everything, but probably not all of you have seen the inside of the marshal's office and know how that operates. So those are other things. And certainly, if there's things that you want to know or learn more about to help you in your role as a new elected official, please let me know and we can schedule some deeper dives or some one-on-ones. That being said, those deeper dives are going to be lots of things that are going to come up where I'm sure that we're going to want to have more time than we have tonight to get into those. I would like to be able to use some of our time at work sessions over the next couple of meetings to go through those. So if there are those and it's sounding like we're going down a rabbit hole of this is probably a deep dive topic, I'll go ahead and make a list and we'll get that scheduled. Outside of that, I want to thank you for answering the call to service to your community. It's really good. I'd like to start with some introductions of our board members, and then we'll go through your what I consider your executive team here. And we do have a couple of folks online joining us from our planning services. So if you wouldn't mind taking just a quick minute, introducing yourselves, maybe what your goals of this term are, or anything else relevant, like what drew you to run for public office, to help share that info with our team.
Hey, I get to get started? Okay. It's glowing. Okay. All right. So John Bell, retired chemist. I was in industry for a couple of dozen years, and also, and then after getting out of industry, had a lot of experience volunteering with the scouting organization, with the school district. So got to see volunteerism from a couple of different angles, and then more recently being part of the Trails group here, and the Trail Ambassadors group. So in terms of what I'd like to do and why I volunteered is there was, two things kept getting echoed during the candidate forum. And I was part of, that voice that was talking about more transparency in general with governance. And specifically what I mean by that is, why are we making the decisions we're making? Okay, I think there was a good example, and Becky and you and I have already talked about it. There was a forum at our first meeting that had both a compliance perspective and a political message. And it didn't hit me until after we made that vote of both of those components, but it's making sure that not only us as trustees are understanding the what's and the whys that we're voting, but also our constituents, because I think that's as having been in the audience, I was asking that myself, what exactly is the vote for, okay? And then the second component of that was the budget, and Bo and I have talked about that, and he's been very gracious, and I've already started looking at municipal best practices. What are they? And are there gaps in what we're implementing and how we're communicating to the public? Those things. So that's it.
I'm Sean Ives. I've lived in town for quite a while, retired, semi-retired, I guess. The reason I volunteer here is just to be to give back to the community that I've lived in for so many years, and continue on with that. hopefully to improve some of the practices that we do as a board of trustees, try to move forward in a town-centric way, try to improve the life experience of the 640 odd people that are residents of the town, so that their experiences are good.
And I'm Mayor Todd Dixon, retired out of the Federal Aviation Administration, had roughly about 15 years worth of managerial experience in that, including the regional certification office. And my wife and I built here in 2020, retired here same year. Basically, we'd been coming out all of our lives, or I've been coming out most all of my life. Every summer, we've got to still have a summer place that is now my brother's. And way back when, about 30 years ago, we saw a piece of dirt for sale and we bought it. And we held on to it until we could afford to build on it. And we decided we wanted to make this our retirement home. And, you know, we've basically been enjoying the town for years. And so, yeah, I wanted to give back, and I have a set of skills coming out of the managerial side of the federal government, and thought it'd be a pretty good fit, you know, for the local governance. So as long as I kind of feel called to do something, I'll do it. But I am retired, and who knows what may happen.
My name is Don Walker. I own property here for 25 years. I'm probably the fourth generation of my family that have come up here and vacationed. I'm the first one to decide to retire up here. Love the community. It's like my second home. My professional education is in petroleum engineering. After about a decade of working in that field, I evolved into proprietorships of various forms in agriculture and construction and so forth, and retired out of that about 5 years ago and moved up here. And so I volunteered. So much like Todd, I've got a set of skills I think the town could use and to make it a better community. And I ran on the platform of common sense government.
Let's go ahead and start with Mr. Leopold.
All right. Well, wonderful. Thank you for having me tonight. My name is Todd Leopold. I'm the Central Regional Manager for the Department of Local Affairs. We provide technical assistance, a lot of grant funding opportunities for local governments around the region. My territory, there's 7 other peers around the state. I cover the central region, which is basically the Denver Metro. I go up to Clear Creek and go out to Elbert County and then come all the way down to El Paso and then Teller County. So provide a, get to work with a lot of cities, counties, and I have over 1,200 special districts as well that I work with. So broad and diverse, but my ultimate goal is to help local governments thrive. And my background is I've been a county manager for a couple different places in Colorado and California, and so just happy to be able to share some experiences and background to help both your staff and our elected bodies around the region. So thanks.
Get the blue button there. Yep. My name's Jeff Parker, and I'm a little incognito as an attorney because I'm not wearing a tie. So I've been your attorney for quite a while now. And actually, I should have the date for that, Becky, but I don't remember now. It's been quite a while. But our law firm is Hoffman, Parker, Wilson, and Carberry. It was started in 1985. I've been there since 2003. Been an attorney for 30 years, almost 30 years. Can't believe it. We have 16 attorneys at our law firm, and we pretty much specialize and represent only local governments. Have a few one-off private clients will help with certain issues, but I think I now have about 24 full-time clients, special districts, municipalities, and a couple counties. I think our firm does probably 50 plus local governments, if not more. Yeah, I'm happy to be your attorney. Hopefully we're giving you guys representation you need. But I'm always up for suggestions, and like working with Becky. You have a pretty good staff, and Bo's good too. So hope we can help you out.
Thanks, Jeff and Todd. Julie and Ben, would you like to introduce yourselves from Baseline?
Sure. I'll start. My name is Ben Thurston. I'm Baseline's planning director. And Baseline is a company with multiple disciplines. We have civil engineering, planning, surveying, and environmental. We've got about 75 employees across 4 offices, and that includes our headquarters in Golden, where Julie and I work from. And then we have a Steamboat Springs office, a Fort Collins office, and a Colorado Springs office. And we split our clients are split for the planning division about evenly between the public sector and the private sector. We're probably working for about 13 communities right now across the state on the public sector side. And then we represent developers through the entitlement process on the private sector side. And I'll let Julie introduce herself.
Hi, good evening. I'm Julie Estrel. I'm a principal planner at Baseline. I've been there about 8 years. Before that, I was a planner in Wisconsin for the city of Janesville. And yeah, we've been with Green Mountain Falls for a couple of months now, so we're still getting our feet wet, but we're building some good relationships already. So thanks for having us tonight. And if I could ask, the person who spoke after Don Walker, we didn't have an audio on. If I could get that person's name just for my reference.
Sunday King.
Okay, thank you.
All right, perfect. I want to thank you, everybody, again. And we've got a quick presentation from Todd Leopold here with DOLA. So if you can get that queued up, Bo. There are going to be some redundancy things. Are you comfortable with everybody waving a red flag if it's a little bit too redundant? And before we get started, did kind of want to ask if anybody had a chance to watch the YouTube video that I sent out yesterday. Did you enjoy that? Okay, good. All right, awesome.
Not better. So basically the agenda is I'm going to talk a little about roles, responsibilities as it relates to you as a board and the staff and what that means. Obviously the conversations we're probably going to have, myself included, will probably be at a higher level please feel free to stop me if you have any questions. Happy to answer those. I'll start with the roles and responsibilities. I'll turn it over to Jeff, and then we'll come back and talk a little about, I call it Finance 101, but it's a little bit about what does it mean from a financial standpoint? If you've worked in and haven't worked in a government arena, what does that look like? Because it is a little different. It's not rocket science, but it does give you some context, and we'll talk through that a bit. So, next one. All right, so just kind of obviously ground baseline foundational pieces. Obviously, government's here to establish those laws and ordinances, preserve that public order and tranquility. Ultimately, we're here to provide services to the community. I mean, at the very heart of the matter, and those, unlike other states, Colorado is very much local control in many aspects, and I think there's a lot of focus to try and continue that. But we'll talk through a little bit about that and what that means. Obviously, there's health, safety, welfare, housekeeping, all these different functions, and depending on what local government jurisdiction you're working with, I have the satisfaction, I guess, of working with Denver in some cases. They have a hospital. You guys don't have those sort of things. So it really varies depending on the local jurisdiction. And then depending on if you're a city or a county, many of times those counties will handle birth and death certificates, those sort of things. But there is a joint relationship that happens with the municipalities and the county itself. All right, so we're going to talk a little bit about, go ahead, you can, the next one, is what's the role as it relates to elected officials, the town manager, and then I'll touch briefly on advisory boards and planning commission, and then the staff. What does that mean? What's their roles and relationship to you, and how they support the organization and you as elected officials? So the first one, let's start with the elected officials. Basically, key aspects, you're setting policy, this kind of commander versus advisor. It really depends on kind of what the topic is. You have a lot of fiduciary responsibilities. That you're basically the stewards of those public dollars. So any questions, I've always said, if you have questions about the budget or the finances, it's really good that you feel comfortable because those decisions that you're going to make have those level of impact to them, and you set the tone moving forward. Obviously, the ultimate goal is protecting that public interest. You do hire and fire professional staff, appoint boards, as we're going to talk about briefly here. But the ultimate goal, and I've always said this when I was in Becky's role and in previous ones, is it's a partnership. It's a relationship between both the staff and the elected body, so that you feel comfortable that you are getting the necessary information to make those informed decisions. And so I always look at that as the relationships not only between your staff, but you reside in, actually, I think you reside in 2 counties, El Paso and Teller. And so I know, Mayor, you do a lot of outreach to those groups and serving on committees and commissions. And I think the relationships between these local jurisdictions, whether it's the other municipalities or the county, I think is honestly critically important. So, and finally, I'll just share with you, emergency management, emergency readiness is another component, kind of ties into the financial investments you're making in the town, especially in an area that's prone to wildfires and some other natural disaster events. This is an important aspect of the job and role as well. So one of the other things that I'll say, and I think it's obviously share, this isn't about special interests. This is about collectively the good of the whole. And so many times when staff and we are talking to you, we're talking to you in the context as a board, and giving personal viewpoints on issues is totally appropriate and makes a lot of sense, but you act in official capacity as the board or the trustees. And obviously approaching issues with an open mind is always important. I always say, you need or have questions, please ask those. But your official capacity, unless you've been delegated by the board to serve on a committee, is in capacity as the group as a whole. I don't want to beat on this, but I think it's always good to just, it's about professional. There's a lot of efforts, both in terms of recording and decisions that you're making. So obviously being professional, big picture thinking. I always say when we talk about the budget, you may be talking about the current year, but you're looking at the next 3 to 5 years down the road. And I think for board members that have been on for a little while, they also say, what's the impact we're making for the future people that are going to be sitting in this role? I think that's always a consideration as well, but always in the best effort. If you're focused on the community, you can't go wrong. So I'm going to turn it over. What's the role of the town manager in this context? There's some key aspects that the town manager responsibilities are. One is presenting a proposed budget to you for the board for consideration. And we'll talk a little bit about what that is and the timing of that. But I think probably one of the key components is that budget. They also are the basically chief administrative officers. So in this context, recruiting, hiring, firing, terminating, and supervising the staff, as well as those that when we enter into contracts or agreements with other providers to provide services, they're the ones that giving guidance to those individuals. They make those policy recommendations, and as I've always said, sometimes you like those recommendations and sometimes you don't. But that doesn't mean it's not important to have all the information provided to you to make an informed decision. There's going to be pros and cons to each of those, and I think I hit at the very end, the decision is ultimately at the board level, and the decisions that you make are the carrying out of the staff, and the staff are the ones that carry out those decisions. But their ultimate goal is to provide you all the information that you need to make that informed decision. This is a big slide. It's got a lot of information. It's kind of probably a little hard to read, but it really talks about the role of the board versus the role of the manager. And you'll have this slide deck. I think it's always a good one. Talks about your role and accountability to the citizens. Ultimately, that role of the manager is that accountability to you as a board to carry out the decisions of the board as a whole. And it kind of references some of the things I spoke to talk to you about briefly in the slide before. So let's talk a little about advisory boards. You as a board appoint and let advisory board members go as deemed necessary and appropriate. But again, that's why they're called advisory boards, because they give advice to you. They aren't the decision making. Ultimately, those advisory decisions are on behalf of you, and you have the opportunity to either take that and agree with the recommendations provided, or make a decision that may be counter to that. But ultimately, the decision making rests with the town board, and we just ultimately, and we talk with advisory committee members. They're working collectively as a board, not individually in their capacities as an appointed member. Same holds true for planning commission, a little more identified in decision making here, but again, appointed by you. They're an advisory capacity. They will review and give input to a master plan or a comprehensive plan that you have in place, and so they're kind of that land use planning designee. They, looking at development applications as they come through, give you recommendations. Ultimately, those go to you as a board, and you'd make that final decision. And in many cases, due to the nature of the role that they're in, staff provide assistance and support to them as necessary. So, planning commission, important component of overall local government services. All right, so that was a fairly brief overview, but it gave you some context of what your role is, what the town manager's role, and the staff that support you all. Any questions that you have, and then I'll turn it over to Jeff if there's anything that's noteworthy from this conversation.
We're going to see these slides later because we went through
I sure did. You'll have the slide decks. If you have some notes, I'm happy to answer any questions. Again, kind of a high level foundational discussion, one just because of the time constraints, but I'm happy to answer any more detailed questions you might have.
All right, so I debated whether or not to do a PowerPoint for y'all. I decided that I would just talk to you. Hope you don't mind. You feel free to ask me questions. I kind of like to have these actually as a dialogue. If a question comes up, just cut me off and ask a question. Am I getting through here? Okay, well, I don't need to be really too close to this. I don't want to get too close. All right, good. Nobody ever really accuses me of having a soft voice, so I always forget to talk into the microphone. Yeah, I think when I went back to the title of what my presentation is about is basically avoiding liability. So number one way to avoid liability is just don't run for office, okay? But the good news is that in Colorado, we have a really strong governmental immunity act. And we also have CIRSA, an insurer that insures a lot of municipalities in the state. You get good attorneys appointed by them. They provide you generally good insurance. I don't believe, I have had some elected official clients of mine be sued. They never had to pay a penny out of their pockets. I don't think it's ever happened for any one of my clients. And I'm pretty sure there hasn't been any elected official at our law firm that's had to actually pay personally for any claims. But, you know, sometimes you do end up having a disgruntled employee. You have somebody who's applied for something, a land use application. You can't prevent people from suing you. You can reduce the risks and you can do a really good job of setting things up. So if you do get sued, you win. And so that's kind of where my job comes in, is that I think it's important for you to know what my role is, what my obligations are, versus your role, employees' roles, Becky's role. You know, my role really is to tell you the law, tell Becky the law, make sure staff gets understands the legal parameters. You know, I kind of joke that, you know, at some point, you know, there's a joke, and an attorney like me, you know, dies and goes to heaven, and, you know, there's basically one law book with one word in it, and that word is yes, right? And that's what clients always want to hear, right? You want to hear, yes, you can do that, but that's not the reality. I mean, you know, especially municipal law, there's nuances, there's different levels of risk. So I try and give you sort of enough information in an understandable fashion where you can understand the risks of various options, and you can do the legal risk analysis. You know, sometimes the answer is that you definitely can't do that. Some of them are pretty easy, but most of the time it's like, well, this has got a high risk, this has a low risk, nothing illegal going on here. You need to be able to make your decisions based upon that risk. And I think another important concept for you to understand is that, or at least I think it's important, is that you can't really run a town constantly worrying about getting sued. You know, you need to know what the risks are, but you can't run a town with an eye on the courthouse at all times. You know, sometimes to get things done, you have to basically take some risk. You have to recognize it's acceptable level of risk, you know, and that's just sort of part of the business. And then luckily you have good governmental immunity, you have good insurance, you have good attorneys usually who can help you if something does happen. So my role is to give you the law, your role is to do policy. And I think, you know, having in-house counsel, some bigger municipalities have like a full-time attorney on staff, several attorneys. Denver has hundreds, I believe. That can be really great to have somebody who just sort of knows the operations. I also think there's a real benefit to having outside counsel. And one of them is that my job, my livelihood is not at stake making you happy, giving you the answers that you want to hear, right? Or that somebody wants to hear. I never want to lose a client, you know, but I would much rather give you something you don't want to hear than give you the wrong legal advice. So the benefit of outside counsel, I think, is that we can basically, we have independence of everybody involved in the town. I'll tell people things they don't want to hear, and that's just part of the business. And if I lose a client over it, that's part of our risk, but we don't, you know, I don't have to go on and not be able to feed my family. And so I think I've lost one client and they hired me back about a year later. So I'm doing pretty well so far. I want to go into just, I guess I'll sort of touch a little bit on what Todd talked about. I'm going to probably overlap a little bit here, but feel free to jump and ask questions just to make sure y'all understand you're a statutory town. So Colorado, you have home rule municipalities, you have statutory municipalities, statutory cities, statutory towns. Home rules derive their authority from the Constitution. depending upon their charter, they can have broader powers than statutory towns in certain areas, like areas of local concern. And usually they do have some broader powers. And sometimes they have council members who are board members who ask, well, how come this town did this or this city did this? And I'll have to say, well, they're a home rule municipality and they have extra authority. They can do that. You can't. Your authority comes from the statutes. And so the General Assembly basically tells you what you can and can't do. So if you don't have authority in the statute, or if the statute, or it can't be implied from the statute, you lack authority to do that. And so you generally have less authority than home rules. Like Matthew Springs is one of my clients down the road. They'll have broader authority than you will in some areas. But a lot of the times it's not an issue, but once in a while it comes up. So just because somebody else did it, there's two reasons why that might happen. One of them is because they have more authority, their home rule. Another one is because they just are doing it wrong, or they're doing something that you may not want to do because there's a higher risk. So it's just, there's always reasons. You can't always just say they did it, we can, right? Todd addressed sort of some general concepts about what your role is and what you do. Like I said, I do law, you do policy, generally, bigger picture stuff. And I have some sort of rules, how I think you should operate. You generally have to act as a body. You don't act as individuals. Unless there's a delegated authority to you, you only have authority to basically take action as a group. And typically that's only during an open meeting that's duly noticed and it's transparent to the public. Where I find a lot of liability comes in is when an individual board member has a particular hot item that maybe that's the only reason why they ran for the board, right? That's that, because they want to deal with this issue, or they have a specific, issue, and then they really push that and they kind of disregard the concept that their role is to act in a meeting as a group. And then sometimes you lose, you use an issue and you got to kind of be able to move on. I've seen some boards where, one board member will just keep challenging a decision of the group, undermining it, backrooms talks, people come in, complain. It's just, it really undermines your whole, your ability to operate. And I think sometimes you also overlook how you set the tone for your community and for the employees here and for the town. When you have a board that can't work together and some members can't accept the loss and move on, it just creates an environment where I think employees feel that they don't feel supported. I've seen great municipalities have a different board and then things kind of go to pot. So it's really important for you to just recognize that. I'm not trying to lecture you, but it's really important to see that. So I say act as a body. And one of those issues is dealing with town staff. And so the number one person who basically you supervise and reports to you is your town manager. That's Becky. If you really can't be going around Becky and dealing with employee issues, number one rule for a board is to stay out of personnel matters other than the personnel that you supervise directly. And that's generally the town manager. And then you'll see employees, this is where I talk about setting the tone. I've seen where probably your number one source of liability is basically dealing with employee issues that you should be letting your town manager handle with me. And that's generally your number one way to avoid liability is to not deal with employees. And employees see that. Employees will basically not like what they hear from their supervisor. Or they won't like what they're hearing from the town manager. And then they'll come talk to one of you and they'll start telling you what's going on or how this is unfair. And you feel like you need to deal with it. You want to run the town, right? You don't have unhappy employees, but the better answer is, yeah, I can't take that. That's not my responsibility. That creates liability for me and for you. You have to work through the supervisory authority. If there's a complaint about Becky, they can come to the mayor, they can come to me, we can deal with it that way. But generally, it's better to stay out of employee personnel matters. Number one source of liability for you.
You might want to highlight that I do have some additional responsibilities especially if Becky's out of pocket.
Yeah, being a small town, the mayor has certain ability to step in some situations, but generally you want to basically be careful around that. And that comes to the Governmental Immunity Act in Colorado and also to your insurance coverage. And I always sort of want to make clear, so the Governmental Immunity Act basically protects you for anything you do within the scope of your authority. So those of you who watched the SURSA video, you'll basically, that's kind of what it's all about, acting within the scope of your authority, not getting outside the scope of your authority, and then not doing anything willfully or wantonly. Because what happens then is you basically lose insurance coverage, and you can be personally liable. And then you also can lose insurance coverage, and you can lose, the defense attorneys they'll appoint to defend you. Because a lot of times when there's something that happens in a municipality, they will sue, the town, and then they'll sue board members or the mayor or certain ones, depending upon who's involved with what. And as long as you're acting in the scope of your authority, and as long as you're not doing anything willful and wanton, which is kind of like you're basically intentionally doing something wrong, you'll have immunity and you'll have insurance coverage. So really good to be aware of that. And then I'm going to kind of segue into how you do that, depending upon the types of decisions that you're making. So I'm kind of the advisor. Becky is also an advisor, a recommender, give you information for decisions. I try and give you the legal basis for decisions, options. You make the decisions. And I'm going to just go on to what's basically known as the distinction between legislative actions, which is basically passing laws, quasi-judicial actions, which is making decisions based upon laws, and administrative actions, which are just sort of routine contract approval type stuff, which most of that stuff is done by your administration. I think the real key difference here is to know the difference between what's the legislative matter and what's quasi-judicial matter. Because what that does is that dictates what you can do without basically creating liability for the town and for yourselves. Are most of you familiar with the concepts of legislative and quasi-judicial actions? I mean, they're tricky. It's tricky. So legislative is basically generally passing laws. And so what you do that by enacting ordinances. So, and what an ordinance does, it basically is something that affects pretty much a broad range of people. It applies to the entire town. And it's basically things like, if you want to pass a criminal law, trespassing law, you want to do in general, big zoning decisions are legislative in nature. And the rules with legislative acts are pretty unlimited. The sort of main rule is you just can't act fraudulently. And so if you're making some kind of legislative decision that somehow is to, some under the table deal is going on, which I've really never seen, the courts don't even really review that. They say this is a discretionary act. There's no particular rules that apply. You can talk to any of your constituents. You can basically be biased. You can prejudge things. There's no real restrictions on that. So when you're dealing with sort of general ordinances and that kind of thing, you're pretty free and clear. And so that's kind of what you do. You don't want to tell a constituent you can't talk to them unless you really can't talk to them. And so the key then is to know what's quasi-judicial. And quasi-judicial is when you're basically acting in the role of like a judge in a case. And so a judge in a case, the parties bring the case to the judge, assuming there's no jury, and all the facts come in a hearing. The hearing's recorded. The judge doesn't go out and investigate anything himself. The judge doesn't get on the internet and try and doesn't talk to any of the parties outside the courtroom. Everything that the judge is looking at is being decided based on the record. And so a quasi-judicial act is with mostly the kind of things like a land use decision. That's generally where you're dealing, where you have somebody who's applying for a variance or a special use permit or a conditional permit or something that basically comes to you for a decision. And what you do in a quasi-judicial situation, you say, well, what are the laws that we previously passed say? What does our code say the criteria are based on this application? So special use permit has to be consistent with the neighborhood needs. It can't interfere with your neighbors. You have all these criteria, and the code will say that you got to consider this, you got to consider this, you got to consider this. And so what will happen is you'll set the hearing, public can be there, it's a public hearing, everything coming to you is presented in the hearing, and you make a decision, you apply the criteria. That's quasi-judicial. And a lot of rules apply to that. And so basically the general concept of due process in the law. So the key is that when you think about due process, you think about it's like a fair process. It's fair. So I don't want to come in and apply for something for my property and present you all this information. Staff provides a staff report. And then I learn later that you basically didn't even consider that. And you looked at the internet and you figured this out and you went and talked to my neighbors, asked my neighbors what they thought. I didn't know that. You know, so nobody knew that. I couldn't address that. So that's where these sort of concepts of personal bias come in, prejudgment, ex-parte communications. In a quasi-judicial matter, you got to be a judge generally. And you can't, I don't like Walmart. Therefore, I'm going to basically not approve their application for a permit, for example. You have to basically look at the criteria. Whether I hate Walmart, love Walmart, indifferent, the criteria are this. Here's what was presented to me in the hearing. That's quasi-judicial. And I can't go talk to people. I can't go talk to the developer. I can't talk to the neighbors. So that's why it's different than legislative, where you can talk to anybody and you can have strong feelings about certain things. Like, I don't think this should be criminalized. I don't think this should be a law. I think that the zoning, when I pass a zoning law, the height restriction should be higher. That's all legislative. But when you apply the law, quasi-judicial. That kind of makes sense. It's tricky. And I get a lot of calls about that. So feel free to call me if you have any questions, because it gets tricky that way. And that's basically how you avoid creating liability for the town. If you basically don't consider things in the hearing, you don't apply the criteria, you're talking to people, creates liability for the town, could be for you. You still generally have coverage under the GIA unless it's intentional. But yeah, that's just really a good thing to understand. I was also going to talk about open meetings, open records, another fun one where courts are getting more and more strict. Any questions about quasi-judicial legislative matters, anything like that? Yeah. Yeah, absolutely. So I kind of just blow that off typically, because administrative matter would be generally like approving a contract for services. I have a hard time coming up with lots of those options, because most of the administrative acts are basically done by your administrator, your manager, and your staff. But you'll have contracts that come to you. That's not legislative. That's not quasi-judicial. That's administrative. And for those matters, you got pretty limited liability too. So you're free to ask questions. You're free to to a certain degree. This contractor didn't do a very good job last time. I'm not really in favor of that. You're generally okay there. The real key is to be careful when it's quasi-judicial. So, that helpful? Yeah. I'll go on to open meetings, open records, and what I'm finding now, I think there is a trend, and I think the general rule, the general concept with open meetings, open records is transparency. As Trustee Bell mentioned, that's why you're here. Yeah, the real key here is the general default concept. Where everything is sort of in favor of is basically providing transparency to the public, to the media. Generally don't like backroom discussions, generally don't like documents that are not publicly available, but there are some exceptions. So open meeting law, general rule is a meeting of 3 or more of you to discuss public business is basically a meeting that needs to be noticed 24 hours in advance, and it needs to be held in public. So 2 of you can talk about anything you want, although quasi-judicial stuff, you really can't. So you can talk about, oh, the roads here are all, I'm not happy with the roads. I'm not happy with snow plowing. I think we should do this. We should change these laws this way. 2 of you can talk about that. It's not a meeting. But the courts are generally moving more and more towards finding violations, and they're getting more strict in Colorado. So 3 or more members, generally to discuss public business, that's a meeting. And it doesn't have to be just face-to-face or on the phone. Texts, emails, any other forms of communications can be a meeting. So years ago, our firm, and I generally felt that an email was like a fast letter. Sent a letter back. That's not a meeting. It's definitely a meeting now, even if it takes 2 days to respond, 3 days to respond. And one of the key rules is that even using your personal email addresses, personal email, personal phones, it doesn't protect you. If it's public business, doesn't matter what the means of communication is. Doesn't matter what account you're using. So be careful with that. So another issue to think about is doesn't look like under recent case law, there's no emergency exception for meetings. So at some point, oh, we couldn't post this within 24 hours. It's an emergency. We had to bring it up in the meeting. It just came up in the meeting because there was, there's no time to do it. Courts are not happy with that. And there's some nuances that we could certainly argue in your favor, but you really need to do 24 hours notice before and agendize the item in enough detail so the public knows what's on the agenda before you can actually act on it. There may be some exceptions there, but I'm nervous now for my clients. That's sort of the general open meetings rule, except for there's some exceptions to it. So you've all heard of executive sessions. I think we've had at least one when I was here, but certain types of situations warrant a meeting to be not in public. You still have to have a 24 hours notice of a regular meeting generally. And in a meeting, you then can go into executive session for certain reasons. And there's 8, I'm forgetting exactly, it's personnel matters regarding a specific employee or specific employees who have not requested that it be in public. So a lot of personnel matters you can do in executive session unless the employee requires you to do it in public. They have the right to make a decision on that. Purchase of property, purchase or sale of property, legal advice, negotiations, developing a strategy for negotiation. Sometimes you have to negotiate a contract or negotiate some deal. That can be done in executive session. There's security concerns where you're basically discussing some kind of security arrangement that you have might jeopardize the safety of the town or anything in the town. That could be one. There's also some other mandatory non-disclosure provisions under Colorado law. There's also some requirements under federal and state law. So those are other grounds, but the big ones are legal advice, personnel matters, and negotiations. Those are the big ones. And with the trend I'm seeing in recent case law, you got to be really careful because the rule for executive session is you can discuss these issues. You got to stay on topic. You have to actually provide as much notice as you can on your agenda. You can't just say it's for legal advice or it's for negotiations. You got to say it's for negotiations regarding whatever you can provide more information about without harming the whole purpose of the executive session in the first place. And a recent case came out where basically the court addressed something called rubber stamping, which is you go into executive session, you talk about the issues, you kind of make a decision in executive session because you can't make a decision in executive session. That's basically not allowed. And you come out of executive session and you make a decision with no basis for it other than what was in the executive session. And so it gets really tricky. This recent case really, I feel like it's not a good case. It's very difficult to decide how can you do anything in executive session then if you can't at least provide direction. Like if we go into executive session for legal advice and you say, okay, we'd like you to try and settle this case for X number of dollars. And there's 5 of you in the executive session. How do you reach a consensus to tell me to do this without making a decision? So I've always been under the opinion that you can do that. You can give me direction. Formal decision has to actually be made in public at some point, but I can go negotiate and then I'll bring it back to you in public for you to make a formal decision. That's what I generally do. Probably still going to give you that advice, but the courts are really making me nervous with executive session. So just be really aware to not make decisions if you can help it and to not like rubber stamp things when you come out. And I'll hopefully be able to guide you if you have executive sessions about important matters. Last thing I was going to mention on executive sessions is something called like a serial meeting or a hub and spoke meeting, which is where Trustee Bell talks to Trustee Ives about an issue. Then Trustee Ives talks to Mayor Dixon about the issue. Then Mayor Dixon talks to Trustee King. Trustee King talks to Trustee Walker. 2 people at a time. Public business, not a meeting, right? Yeah, I think it's a meeting, right? The courts are now saying that's going to be a meeting, particularly when it's done with the purpose of avoiding the requirement to basically do it in public. Okay. So be really careful with those kinds of things too. So that comes back to my number 1 rule, which is in most cases, when you're dealing with public business, try and do it in your meeting when it's been noticed versus together outside of the meeting. Just that's the way to avoid liability. Open Records Act. Once again, the bias is generally that all records are public records unless an exception applies. And so my sort of rule of thumb is, Jeff's rule of thumb is, so this is like emails that you write to each other, texts that you write to each other. Anything like that is basically a public record, even when it's not in your private account. A little harder to get at when it's your private account, but somebody really wants something, they're going to go to court, they're going to get it. So my rule is, don't say anything in an email or a text that you don't want on the front page of the paper, or you don't care if it's on the front page of the paper. I've been through some pretty nasty open records cases. I've had requests made where there literally are probably close to 100,000 documents. And we cull through these things, and you have to do a review of the cost of fortune for the client. And then there's the one email where I think, oh, why did he say that? He's going to be this, he's going to be so embarrassed. He didn't really, I know he didn't mean it, and I know he's just spouting off, but I always, just hang out before you press send. That's a great rule of thumb. And I do that myself. And I actually one of my clients got sued for legal advice that I provided to the client. We didn't disclose it because to an open records request, because it was attorney-client privilege. The court ordered us to disclose the email to the court, so the court could decide whether it's attorney-client privilege. We actually fought that to the Supreme Court, but the whole time I wrote that email. I remember writing that email thinking like, oh, I'm going to write this exactly the way that I want the court to read this. If the court reads this, or if the paper reads this, get my client great, perfect advice. It was all just perfect, and like we fought it to the Supreme Court. So we didn't like the idea the court could even look at it. We thought the court was wrong on the law. And at the end of the whole thing, we lost. And I gave the court the email, and I was kind of chuckling. So I'm like, this is going to be, the court was worried that I thought, oh man, we got him. Right? This has got to be a terrible email because they're fighting this all the way. And it was like the perfect email, the perfect phone call, right? It was a perfect email. And like within like a day, the court ruled attorney-client privilege, not disclosed. So I always, with your emails, same thing. Just really think about that. Let me see what else I got on my notes here. Let me see, some other stuff I wanted to mention really briefly. Oh, Becky had asked me about sort of the issues about policies versus laws. Okay, I listen. So I'm taking a lot of time. Are we okay for time here? Okay, I want to make sure I stop before all your eyes glaze over. So apparently, this is kind of a new question for me. I actually haven't really been asked, like, well, what's a policy? What's a law? How do these things, what's the difference between these two things? So I kind of look at, you act in sort of two main ways. You basically pass ordinances, or you do written resolutions or motions. This is going to lead into the policy versus law issue. Ordinances are laws. So you got to basically do them. You got to do them in public. You have to basically publish them. They don't go into effect until 30 days after publication. It's your legislative authority. They're enforceable under your code as code violations. So if anybody violates them, you can go to muni court, you can enforce them. Resolutions are generally more for administrative acts. And they don't have to go through the public hearing process. They're effective immediately. They're generally the kind of thing you can change more easily. They're more for sort of flexible items that you want to basically either an administrative issue, or you want to be able to update things more readily versus having to, do the hearing and then, the 30 days of publication, the whole thing. They basically are much easier to pass. And a motion is just an oral resolution. So some laws require written resolutions, certain things you have to do via a written resolution, some things require ordinances, a lot of things you can just do via a motion. So there's really no difference between a resolution or a motion other than the resolution's written. And in some cases it's required by law. And so I look at kind of like laws are what you would do by ordinance, and policies are what you do by motion or resolution, or you would have Becky do, because it's something within her purview that she doesn't need you to review or approve, even though she certainly could bring things to you for your approval, depending upon what she's addressing. Like she may have a resolution about, what did I have for an example here? I was thinking, like department head reporting requirements to her. Here's my policy. I need a report from every department head end of the month by this date. It's got to include this. It's just a policy. She may have it in writing, may not be, but you don't need to see that. Your policy may be the HR manual. You definitely review and approve all HR policies. Becky may develop it, may bring it to you, but that's the kind of policy. It's not going to go in your code. It's not a code violation. It's just an employee violation or an employee issue if it's not complied with. Department heads might have their own policies, equipment use, break hours, break policies, that could be a department head policy that Becky would probably want to approve, but it wouldn't come to you. And so once again, I think policies are more flexible, can be changed quicker. Don't go in your municipal code. They're less permanent in nature, easier to change, more specific items, not as generally applicable. And I think, I think Becky was asking, well, how do we make policies? There's no real rule on that, but I think there's been maybe some of your boards and commissions and committees, like they can certainly advise on policies depending if it's in their purview, but they don't have any, as Todd said in his presentation, boards are almost always advisory, or any kind of policies they're going to create or present are going to be advisory. So even though like the planning commission makes certain decisions, if they're going to advise you on the comp plan, it's all advisory. Maybe another one of your committees might advise, let's do a policy on this, and that's fine, but they don't get to make them. You get to see them. You get to approve them. So I think you need to think about how you want to process for making policies, a policy for policies, right? And I think that generally any boards or committees or commissions that want to create a policy, they can certainly, there's no rule they can talk to you. It's no problem. But I think there should probably be a flow because, policies have impacts, right? They can impact how operations work, workload on people, what's appropriate. So it's usually better to have the boards and commissions work through town manager to sort of control the policies, and she can bring them to you. Boards and committees can come to you with policies. But they certainly can't enact their own policies that are binding on the town. That's for sure. You have the authority to decide that. I've been babbling here pretty fast. There's a lot of material here. I'm trying to think if I'm forgetting anything. I think I covered most of the stuff you wanted, right? Happy to talk about anything else. Answer any questions. I think I covered everything that I was asked to cover. Hopefully not too quickly for y'all.
So what do most small towns get sued for?
Employment matters. Yep. Yeah. Employment matters number one, probably number two, land use decisions. That's how I see it. Yeah.
When's the last time we got sued?
Have you actually had a lawsuit filed? You've had some EEOC claims. You've had unemployment claims. I don't think you've actually been in court. I'm trying to think. You haven't actually had a lawsuit filed.
Not that I.
Should be knocking on wood right now. Yeah. Mostly administrative type action since I've been here.
Mhm.
Yeah,
Thanks.
sure. Yeah.
I want to go back to policies.
All right.
So thank you, because, Becky's prepped you because, this question recently came up, and even with the policy that you reviewed and redlined.
Forget which one that was.
It
Staging, but it wasn't you, it was Austin. I think.
Okay, Austin.
Oh,
Okay, yeah,
I
it was one of my associates. Okay.
Okay.
Yeah.
So in the introduction, Jeff, you said that you had 24 municipalities that you represent.
Yeah.
In terms of best practices, are there municipalities that are adopting policies in the way that you're talking about, and that we're struggling with, how to, what to?
Yeah, that's a great question. And I'm honestly not positive because I don't think I usually get involved in many of their policies because they're mostly not really legal issues. Clearly employment manuals are. So I'll definitely look those over, and those definitely go to the governing body. And they're usually handled via their HR individual or their manager administrator, and then they go to the board. That's the employment manual. But I don't know how they all do them, to be honest with you. But one of the reasons why I don't see a lot of issues with it. And that's when Becky mentioned that to me. I thought, well, I've never really been asked about that before. Maybe there are behind the scenes. But I think generally if there are, they probably have a manager administrator who kind of gets control of them to some degree, and then has a system for basically making sure that, they aren't just going straight from a commission to the board, because, there's considerations that the committees and commissions and the boards don't necessarily think about when they're thinking about a policy, how it impacts staff and what staff can handle, and budgetary issues and stuff like that. So, I mean, I'm kind of making up the best practice, but it's kind of in a way, it's kind of obvious that's how it should be to work.
So related, are you aware of municipalities with ordinances that address the construction and where they fall in hierarchy for following policy?
Good for ordinances that address construction of policies, how
Yeah.
policies are made. I'm not aware of that. I don't think I've seen that. Yeah.
All right.
What there will be is an ordinance like you have saying, here's the town manager's duties and responsibilities. And then you kind of flows from that she's in charge of administrative policies, employee issues, that kind of thing. So, yeah.
Right.
Yeah.
Thank you.
Just a comment, I would think as long as we are clear that codes and statutes take precedence over any kind of policies, then it basically gets into internal workings of the town.
Yeah, I mean, ultimately, there's a hierarchy of, what supersedes what, Constitution supersedes everything. Laws next, statutes, and then your ordinances, and then policies. So kind of goes without saying, but I mean, you definitely can't enact a policy that changes a law. That's a legal rule, so. Clear as mud. Yeah, it's like I said, one of the other issues I deal with is that, the law is kind of always morphing, right? Like what I'm seeing right now is with these open meetings, open records laws, the courts are getting tougher and tougher on towns, cities. They're basically ruling more in favor of the challengers to records requests, more in favor of challengers to the meetings laws. Several years ago, there was no case law in Colorado on the serial hub and spoke type meetings, and now there is. So it makes me more paranoid when my clients have executive sessions, and it's definitely better to be much more careful now than things were. And it's easy to violate, frankly. If you don't know what you're doing, it's easy to violate these rules. So
Have you had any issues with any of the accessibility requirements that are?
it's a whole nother one, right? Yeah. So that law was passed, a couple of years ago. You're supposed to have an accessibility. It's supposed to be all accessible by July 1st of this year. But then, so there was the law that was passed, and now there are regulations passed by the Colorado Department of OIT, I think it is, Information Technology. So the regulations are giving communities more flexibility to meet those legal requirements. A little worried, that's not a rule. Like regulations can't change the law, but they can interpret the law. And so the regulations are helpful because that law is really onerous. Everything has to be accessible, at all times. And the regulations are like, well, let's make this practical. And, it says that there's different ways of doing that now. And if you have a plan in place and you're working towards the plan, that's going to be okay. So that'll protect you from any kind of state action. But I still get concerned that there's going to be, disability groups who are going to be looking for communities that aren't complying with the law strictly. But I think everybody kind of recognizes that law was just way too difficult, too costly to implement, just boom by this date. And so I think you can really take reasonable action to make things accessible in a way that's not going to harm anybody. So hopefully you can comply.
And have you heard anything specifically regarding the archived material?
Yeah, so the way the regulations work is that it says that it has to be it's like information technology in use. It has to be accessible, or it has to be a plan for accessibility, and there has to be a process to make it accessible. And then any archive material upon request has to be made accessible.
So it's on request.
Yeah, that's the way the regulations read. Yeah. Yeah.
Is the term regulation and policy and legal jargon, are they parallel?
Not really. So, and just, I guess the general legal term regulation is typically enacted by a federal or a state agency to implement a law. And then a policy is something less.
But conceptually, isn't it the same? Wouldn't the policies that we develop be interpretation of our Muni code.
Well, I guess it would depend upon what you're doing. I mean, so you can, in a way, adopt regulations too. It doesn't really have, there's nothing really in Colorado law about like municipal regulations, but you can adopt regulations and they can be, it depends on what you're doing. So I guess depending on the substance of what you do, it could be a regulation, although you call it a policy, right? But a policy could be, policy on when supervisors have to provide Becky with a report. That's not really a regulation. That's not interpreting any law that you have. It's just an internal operational policy. But if you did like a policy on, I'm trying to think like, you have a law that says if you want to have a demonstration, just clearly making this up, you have to fill an application and with all the information that's required by the clerk's policy. And then the clerk has, here's all the information I need. That's going to be something that you can enforce. You didn't do that, we're not going to give you your permit. It's maybe called a policy, but it's kind of like a regulation. Is that helpful? I think
Clear as mud.
yeah, I'm probably being too legalistic here because I think policies can be different types of policies. They can be
Understood.
statements of law, or they could be internal things that don't really.
Well, I'm going to kind of, just check off on it. Conceptually, there is the same process in that in certain instances we are interpreting, we want a Muni code performed in a certain way. We want to regulate it. So,
Mhm.
but we would call it a policy or a regulation, which would be best.
So here, I guess the best thing to do is if you're not clear about your code, something you want to basically deal with, I would try and put it in the code. If you can get clarity in the code, and then the law would say that, okay, here's how we're going to basically implement this law, perhaps, or how we're going to do things, then that would probably be like a regulation. And people could challenge that like they do a law. Say, oh, that's not consistent with the law. So I think that I would, I'm going to ignore the internal operational things that are like policies and go to like, how are you going to implement a law? That would be a regulation, even though you're calling it a policy. It could have legal effect. I guess I'd have to see what exactly you're doing. Because if it's not clear in the code, I'd say, let's put it in the code. Let's make it more clear so you don't need an interpretation of it. Does that make sense?
Yes.
Okay.
There are,
Yeah.
there are things called incorporation by reference. So like if we had the code, basically in your example saying, we need this information in accordance with, that's kind of an IVR type of situation.
Yeah. And so that actually, there's a whole process in the statute for referring to other laws, basically, or others, like, when you adopt a building code, you adopt it by reference. And so, you're adopting something else. It's not really a regulation or policy. You're adopting another law, really. So it's similar. Yeah, it's similar to that. And I'm sorry to be hum and hum because like the term like municipal regulation, they are allowed. I just don't see them that often. I usually see in small towns, especially. Let's put it in your code, make it clear. And then implementing regulation may be helpful. It'll just depend upon what you're doing. So having a hard time sort of seeing exactly how we do that, but you could do it for sure. You're welcome.
I have a couple of examples of how we have codified or made part of our code some of the policies, and those include our financial policies, procurement requirements. Those were probably started as a policy and then they ended up becoming codified at one point in time before it was, or when it was revised and adopted. We have, been working through a couple of things where we've been looking at, okay, what's our internal policy for going through this process with the new use of some of our parks and facilities, being able to have alcohol down there. That's one of those things. And then probably the renewed interest in people renting the pool facility and the gazebo. It's come to our attention that, what would really take care of this is a facility use policy.
Yep.
And so of course, those ones do have some impact on your fee schedule. They're going to be coming to you. As soon as we have spare 5 minutes, we can get something drafted. Did that help to kind of clarify how a policy kind of gets codified?
Yes.
Okay.
I didn't know you were using that process.
Yeah, it's, you know, there's definitely cleanup work. The sophistication of local government is ever evolving. And so it's, that's what we really try to focus on here is keeping up with the times and making sure that we're aware of all of the new legislature that passes and incorporating that into our processes and our internal policies.
Yeah, pool use policy is a really good example. Does that really need to be in the code versus, because you're gonna be changing it a lot, so, yeah,
But we want it in the fee schedule.
right, right. I wish I could make it perfectly clear. You wouldn't even need to call me or spend any money on me. It'd be awesome. So thanks for listening. I'm happy to answer any other questions anytime, so.
All right. There's no other questions. We can, let's jump back. We'll talk a little about financial information. I'll try and not, Jeff did a good job keeping it lively, but, I'll try and do a little better job. Really what I want to do is talk a little bit just foundationally again. When we talk about budgets, we talk about finances, what are the basic foundational principles in terms of terminology that we use from that standpoint? So if you want to hit the first slide, I'm going to walk through just a couple things so that when you hear conversations that take place from staff, you see information that's provided to you. What does it mean? It gives you a general foundation. First off, governments have a unique accounting structure that's called government of fund accounting. Basically what it does, it's the opportunity to identify dollars in certain buckets. I think that's probably the easiest way. The baby of the jurisdiction is usually the general fund. It's the most flexible. It has dollars, usually sales tax comes in there, general revenues that you can use for specific purposes for general governmental services, most flexible of the funds. But then you have other ones for specific purposes like a capital fund. So capital or major expenses that you incur. There's something called a conservation trust fund. You'll hear it called CTF fund. These are lottery proceeds that come to you on an annual basis, dollars that can be repurposed for really for open space related, park related purposes. That's the majority of where these dollars go to. But these are opportunities, and the way that we account for dollars is through a government of fund accounting structure. And I think you guys, Bo, what do you have? Four or five different three funds? Okay, so yeah, so you guys pretty straightforward. The general fund, capital fund, and then the conservation trust fund. There's different types of money. How we, oops, sorry. Oh, you're still on.
I was gonna go with it.
Nope, stay there for a second. So cash basis, let me talk a little bit about that. That's really talked about when we talk about accounting related things. So cash basis, money comes in, we realize that money. That's dollars, cash in hand, or expenses that are incurred. But from a budgetary standpoint, we deal with it in what we call a modified accrual basis. This is where we estimate revenue coming in. We estimate expenses going out through the course of the year. It's how when you talk about the budget, when we put something together and your staff do, they're going to say, hey, we estimate this amount of revenue for these specific purposes coming in, and we estimate we're going to spend X amount of dollars. It's kind of what we call our modified accrual basis, or what you see. Some people will call it a budgetary basis as well. Just to give you some foundational terms, personal services, usually an organization, probably 7% of your overall operations are staffing or personnel related. I'm not sure what yours is, Becky, but a little higher. Okay. So when we talk about personal services, usually that's salaries, benefits, all the things attributed to the staff and the resources put toward it. Sometimes that's about temporary staff will be rolled into that, or sometimes even contractually, you may have someone that comes on, but personal services, the biggest portion of your budget in most cases. Fund balance. You'll hear fund balance used in the context of each of the funds. So the general fund has a fund balance, capital fund does, the conservation trust fund does. Basically what it is it's your revenues minus your expenses, how much is left. That's your fund balance. Within there, and I think, let's see, let me just make sure within a fund balance, you can have things that you say are designated. So in this case, the next piece is our TABOR reserve. So statutory requirement of having a 3% TABOR reserve in your fund balance, usually for the organization as a whole. Usually it's housed in the general fund. These are statutory dollars. It's a minimum amount you have in a fund balance for unanticipated emergency costs. Typically what occurs if you did tap into those dollars, they need to be replenished the subsequent year. But there's restricted in your fund balance and there's unrestricted. So money that you've identified for either future capital purposes. So sometimes you hear it as a sinking fund, you build up money, pay for the item, comes down, goes back up. You'll see that in a fund balance. And then you'll see things that are called undesignated or dollars that are available for use that haven't been identified or allocated for a specific purpose. Many times that's reserves that you have in place and that are general above and beyond the TABOR reserve. Kind of touched about it on that restricted piece at the end there. So let me jump to fund terminology or budgetary terminology, I should say. There's going to be a proposed budget that you're going to be seeing. You'll be getting that. That's obviously, I talked about this is one of the roles of the town manager as a staff, and Bo's instrumental in this role. He'll be presenting and Becky will present a proposed budget to you to start with. This will be the opportunity to review things that are needs. Usually you're talking with each department head. They're proposing needs that they may have, whether it's public works or your law enforcement related services will bring forward recommendations for your consideration. At the same time, they're doing estimates of revenue to either cover those increased costs or how they control the expenditure side of the house. There'll be an adopted budget. That's the budget that after the proposed, after you've done reviews, after you've got public comment on the budget, you as a board will actually do a resolution, will be appropriating the dollars for the upcoming fiscal year. That'll be your adopted budget. In most cases, there's two primary core functions. You have your operating budget, that's your personal services, as we talked about. There'll be materials, supplies, operating related things to run the day-to-day operations of the town. And then you'll have a capital budget. And this is what we've talked about. We talked about this a number of months back, but how do you develop a budget where these are big capital items, whether it's equipment, building maintenance, building repairs, things that are known at the time. You'll have a capital budget. Usually you're looking 5 years down the road, but you're only adopting that current fiscal year. So even though we may be looking at, hey, we have a building or we have a pool that you may have a big expenditure. You may not have the dollars now, but maybe 2 or 3 years down the road, you want to make a good expenditure. You may adopt a adopt a capital plan, but you're only appropriating that current fiscal year. But it gives good planning horizons, so you know how to plan for the revenues and the future expense around that. The other piece is the course of the year. Once you made an adopted budget, you start the year off, but things happen. And as I say, a budget is a strategic planning document for the organization, just like any other business that you've been a part of. Things will change, and whether you may realize some additional revenue. Many times that comes in the form of grants where you've applied for a grant and you were awarded that money. Ultimately, there'll be an expense. So the revenue will come in, the expense will go out. At the end of the day, you'll have to do a supplemental appropriation to appropriate those dollars above and beyond what your adopted budget was. Sometimes it's a cleanup towards the end of the year. Other times you may say, hey, it's substantive enough that we need to take action on that. And usually there's a resolution it really varies. I've seen people do them very frequently, usually larger organizations. Smaller ones will be a little more concise and do it whether at the quarter or semi-annually or towards the end of the year to do the cleanup. But in any case, that's the process that's used. You'll also hear some terminology that's we obviously call revenue and expenses, you know that. But you also hear the term sources and uses. Source equals revenue, use equals expense. Sometimes there's this terminology that's interchangeable. You'll hear that a lot in like an accounting document or a annual comprehensive financial plan or report. We'll talk about uses and sources, and sometimes we use it interchangeably. So they aren't two different things. So those are the high level pieces as it relates to the budget. Let's talk a little bit about timelines. This is a little hard to read. I'll walk through it briefly. There's a lot of nuances within this, so it's not that simple. I wish it was. But in August, you are going to be starting to prepare a proposed budget is usually the time frame. Conversations in June, July lead up to those that kind of initial preparation that occurs. Bo's working overtime and he has a few other things that he's doing at that point. But statutorily, you have to have seen a proposed budget needs to be presented to you as a board by the October 15th deadline. That's a statutory requirement. All jurisdictions have to have a proposed budget presented to them. You also statutorily need to at least have one public hearing. Many times you may do a public hearing at the time of the presentation of the proposed budget. You can do multiple ones. Doesn't preclude that from occurring. It just in statute requires at least one public hearing. The adoption of the budget at that point, any modifications that occur after that October 15th timeframe or sooner, if you're presented it a little sooner, sometimes that happens. Those changes will occur. You'll get dialed in a little more on revenue projections and moving forward towards an adopted budget. The adopted budget needs to be presented usually by the end of the year. December 31st is the timeframe. This was a little unique this last year because there was some changes in property taxes and how that calculation was working. So there was a delay, but typically it's by December 31st. I always tell most of my jurisdictional clients, do it by the 15th of December. After that, what ends up occurring is holidays and all other things. So I think you guys have been pretty good. In fact, I think end of November or 1st of December, you guys have been right in that ballpark. So an adopted budget comes through. Then by the end of February, it's usually 90 days after submission, but usually you get a budget in to DOLA, to Department of Local Affairs, a couple of the requirements of local governments to submit their budget to DOLA, and that happens usually in the February timeframe. And then kind of things start, you'll have the closeout. Usually have the January closeout period from the subsequent year. You run on a calendar year, so that's the fiscal year is the calendar year. Little unique, the state runs on a July 1 to June 30th. So we get the crossover of the calendar years, but you all run on a calendar year basis. There'll be a closeout. You'll have an external auditor that'll come in and do the cleanup and make sure everything's appropriate. That usually happens in that March, April timeframe. Is that generally? Sometimes they get delayed. Sometimes the closeout is really what we're talking about. So that they call it the annual comprehensive financial report. Used to be called the comprehensive annual financial report, but I don't know why. I don't know what they do, but I'll just say that they changed the terminology, but it's really your formal document that speaks about how much you've spent, how much you received in the given year, has the fund balance information. It kind of starts the year over. And then we come back to, as I kind of mentioned, this June through August timeframe. You start talking about the next fiscal year coming up and kind of projections. So it is kind of a year-round process. this is obviously is much more simplistic than what goes on behind the scenes, but I did want to kind of share with you what you should be expecting. That August through September, October timeframe will be a good conversation you'll have about the budget for the coming year. So let's talk a little bit about best practices. Obviously, there's a lot of work that can be done here, but I wanted to talk about the key overarching pieces that create really a solid budget for a municipal government. The most important was probably a structurally balanced budget. When I say structurally balanced, revenues or expenses do not exceed the revenues you're bringing in. Here's a caveat though. In some cases, as I mentioned, fund balances, you can build up a fund balance because you're going to have a capital expense or some sort of big ticket item, usually a one-time expense. And so you make your revenues, your expenses may exceed the revenues you're bringing in, but you're using fund balance to make up the difference. So that's the way you balance the budget. Typically, when I look at a budget, I'll look to see, hey, is it structurally balanced in the sense of is ongoing revenues meeting ongoing expenses? That's really when we're talking about that. And there's some nuances around that, I'll be honest, but you can usually see it over time. Your fund balance will be declining because you're using these fund balances were one-time items. You've generated money and it keeps going down over the years. Yeah.
So I haven't seen an outline for our financial reporting. Are these items going to be on there, ongoing
Yeah.
expenditures?
Oh, yes.
and,
Expenditures,
ongoing
revenues.
Revenues.
Yep. You
Those
give
are
an
all on.
update of kind of what's been spent. Are you doing it quarterly or what's?
Yeah, so
Here, look.
we launched a draft report that kind of pie charted our expenditures through the end of March 30, or through the end of March. No, it was just through the end of it wasn't quite first quarter because it was up to date to March 1st. So we didn't have the entire, and we kind of launched a draft of that and sent it out to the board members, got a little bit of feedback on it. Some were happy with the content of it. And I think the others wanted more level of detail.
I will tell you, and we had some of this conversation, and Mayor, I think you're obviously involved and a council member or trustee on this conversation about reporting and quarterly reporting, and some is just timing of when revenues come in and when expenses come in. But I think you're going to be seeing either a quarterly report, but you usually will see it the month or two after the end of the quarter because they haven't realized or seen that money come in. So I think showing them that report is a good thing. I think it's a work in progress. It's really a question of how much detail and involvement you get, but I think there's good information that can be provided from that.
And the ultimate report is the audit.
Yeah, exactly. And you will get a final update once the external auditors completed their audit. They usually come in, give you an opinion, and give you an overview of what they saw in the budget. So, and the actual expenses through the course of the prior year. So you'll see that as well.
Thank you.
Yep. I kind of talked about this one-time revenues used for one-time expenses. I use some examples, grant funds many times, unless there is an ongoing grant. And I will be quite honest, there aren't a lot of ongoing operational grants. You don't see a lot of funders paying for ongoing staff. They may tell you that, hey, if you hire this staff person, we'll give you some money, but usually once that is expired, that's on the jurisdiction. So I would just be really cognizant of using one-time revenues for one-time expenses. That's a good way to stay in balance and kind of a simplistic way of talking about it. I also talked about our capital improvement plan. We had the same discussion with the trustees and Becky, and I think our conversation was really about, hey, how do we look longer than the current fiscal year? Because we know we have some big time expenses that'll either come up, whether it's water related, whether it's pool related, building infrastructure. So having a capital improvement plan makes a lot of sense. Again, you're only appropriating that current fiscal year, but it gives you a game plan for a couple of years out. Another thing that we did have some discussions about is improving and updating your financial policies. I think you guys have done a really good job in this space. Obviously, we can work on those about what areas would you like to see improvements on, but I think the financial policies have been a good moving in a really positive direction here. And then finally, part of policies could be about reserves. What level of reserve do you have in each of your funds? And it's really predicated on variances that occur in your revenue and the revenue streams. I see it working in a counties, they have reserves, but they're all property tax driven. So their fluctuations aren't as dramatic. In a city or a municipality, sometimes sales tax can go up and down fairly quickly. And so having appropriate reserves to cover those fluctuations, I think it makes sense. Sometimes it's an estimate of the estimated reserve or revenue that you receive. In some cases, the jurisdiction will look at about percentage of your overall operating expenses in that given year. So I would just encourage you to have some sort of policy about your reserve threshold, because then you can say, hey, we need to aspire to get to this point, or we're in good shape and we need to be cognizant of the expenses that we're doing through the course of the year. So again, some foundational building blocks as it relates to budget and fund balances, but I think you guys are, I think, financially positioned well. But I do think being cognizant of the revenue streams are important too. Any questions that you may have about this? And I know you're going to see more of it. So it's a big proponent and a big piece of you serving on a board is really the financial position of the organization. Okay, so that's my piece there.
Thank you, Todd. We do have baseline on Ben and Julie. And they might have something. Ben and Julie, did you have something that you wanted to screen share?
Yes.
Perfect.
Yes, we do.
Wanted to give the board just a little bit of an update. Baseline took on quite a heavy lift with us getting started. There were several projects that were just kind of at that point of initiation or had become a little bit stagnant. Want to thank them for helping work through that backlog. Things are certainly becoming a little bit more efficient. It has been challenging. It's been definitely a time burden for me. But thankful to have them on and thankful for their patience and mostly for their willingness to get to know the community.
Thanks, Becky. So we have a short presentation, and like others have said, we're going to give you a pretty high level overview. What Becky asked us to cover is land use and development review for Green Mountain Falls. Before I turn it over to Julie to start, though, I'm going to take a slight detour over to your municipal code. And if you know, hopefully this is something you've seen before, and if you haven't, you'll see it a lot. The link that's on your website to the municipal code takes you to this third-party Muni Code website, where most of the codes in Colorado that I'm familiar with are hosted and codified by Muni Code, like yours is. And the main thing, really two things I want to mention. One is that everything that you see in our presentation comes from your code. It's not, none of it's general best practice for any town, Colorado. We certainly have a lot of knowledge about that, but what we want to share with you today is really how your code functions and how it's set up. And it's relatively new. It's only, you know, we're coming up on maybe a year and a half of it being in place. So I think it's a work in progress. I think it's pretty good. I think that's the conclusion that I've reached. There's a few oddities that we found, and we certainly found that in the land use table. I think there's some other areas where there could be improvements made, but for the most part, structurally, I think it's pretty good. So that's the one thing I wanted to say. The other thing I wanted to kind of touch on is what Jeff brought up about legislative and quasi-judicial matters. And the vast majority of the applications that we bring you are going to be from private property owners who have some kind of land use request on their property. And those are all going to be quasi-judicial. And it'd be nice if it was a hard and fast rule that every time you passed an ordinance, it was legislative, but it's just not true, because especially in the land use realm, you're going to pass ordinances to rezone an individual's property, and that's always going to be quasi-judicial, even though you're passing an ordinance. In rezoning, when you're doing anything that's site specific, that's going to be quasi-judicial. When you're doing anything that's more general, like you're rezoning a large area of multiple property owners, then that's likely to be legislative. So that's just kind of a rule of thumb. Just most of what we bring you is going to be quasi-judicial, and you'll find out in our presentation that the board doesn't make all the decisions. There are a handful of application types that the Planning Commission is responsible for actually making the final decision, and any appeal would come to you. And that's why it's important for us to share this same information about a quasi-judicial with the Planning Commission, because they act that way as well when they are the final decision-making body. So with that as an introduction, I will turn it over to Julie.
Thanks, Ben. So we first want to talk about the basics of land use. There are a number of application types that can give property owners certain, what we call entitlements or rights to do certain things on their properties. Some of them are development permits, like site plans, conditional use permits, or temporary use permits. Ordinance amendments, like Ben was just mentioning, rezonings or rezonings to a PUD, which is a planned unit development. And land use code text amendments. And like Ben mentioned, some of those are quasi-judicial, even though they are ordinances. General text amendments are generally legislative, I would say.
Yes.
So there are flexibility and relief applications if you have hardship and you want to do something on your property that the code doesn't allow, setback or something like that. You can apply for a variance, minor modifications as well. And then there are appeals. If a decision was made by one of the commissions or the board and you want to appeal it, then that's an actual official land use application type as well. Subdivisions include, division of land, basically. There are minor subdivisions, which usually in the town code in Green Mountain Falls apply to 2 lots or fewer. And major subdivisions are anything that would create more than 2 new lots. Major subdivisions include the 2-step phase, which includes the preliminary plat and the final plat. And generally, those are separate applications. I'm not 100% sure, Ben, in Green Mountain Falls, if those are actually, I believe they are separate applications with separate fees.
I believe so too, yes.
And then there's a historic preservation, which you can apply for landmark designation or other certificate of approval if there's a historic structure. Sometimes those have to go under historic review before they can be approved for whatever amendment or improvement or change.
Yeah, and just to reiterate, this is the sum total of the application types you have in your code. These aren't just a list of examples. This is the list of what you have in your code that people can apply for.
Thanks, Ben. So the land use approval process starts out with a pre-application conference. Based on your code, they're required for site plans, subdivisions, and rezonings. There can be optional for others. There is a formal submittal requirement. And during the pre-application conference meeting, phone call, or other correspondence, the planning staff will assist the applicant with kind of determining what kind of application they need in order to do what they want to do on their property. And then they'll also briefly talk about what the application fees will be, what the application checklist items will be for them, so that they can submit a complete application. So that leads us to the next step, which is the application submittal and the payment of the fees. So once the application is received by planning staff, we go through the checklist, we review the application for completeness, we confirm that the application fee was paid. There's a note here that it is in your code that there is the ability for the town to pass on fees for outside consultants. And we do keep track of our efforts on a as case basis so that the town has that ability to recover those costs if you guys desire to do that. And then the final portion of that second step there is for planning staff to send that application out for referral, which is another word for review. We refer to outside agencies, generally primarily engineering. Kiowa Engineering is the town's engineer. They're a consultant engineer, like we are a consultant planner, and applications can also go to emergency services or to schools, if there's a school district, to CDOT, if there's access onto the highway, and those types of agencies. So that leads us to the third, which is the application review process. Once the application goes out on referral, generally there's about a 2-week time period allowed for agencies to respond back. Town or planning staff reviews those, compiles them, summarizes them, and forwards them to the applicant for corrections, additions, clarifications, and then awaits resubmittal of their application. And then that will go out on referral again. That would be the second referral on the second submittal. And that can happen again and again. Generally, applications can be wrapped up within about 3 submittals. And then usually the 4th submittal is the final one that's generally approvable. Sometimes there are items that are a little bit outstanding. Maybe there's 1 or 2 things on that 3rd submittal that didn't really get exactly buttoned up. And planning staff, along with town staff, can determine if that's ready to go in front of the planning commission or the board for review and decision before every single item is addressed perfectly. And then those items will be considered conditions of approval, and those would be listed officially in our staff report and in the motion. So that includes kind of the application review and revision portion. Then when it's ready to go to either the plan, well, and we'll back up. Following this, we'll talk about who makes the decisions on each of these, but generally applications go to plan commission at least first. And so a lot of times the first review body is the planning commission. And so staff would make a staff report with a recommendation based on the findings that are in the code for each different type of land application. And then it would go to the planning commission. Sometimes generally there is a public hearing that's required also, and that's listed in the review table in the code that indicates what items need public hearing. And once the public hearing has been noticed and the meeting has been set, the staff report is prepared, it gets sent out to staff, and then we hold the meeting. Staff will, or not staff, but the board or the planning commission will open the public hearing, listen to public testimony, close the public hearing, have discussion, and then generally make a motion to either approve with conditions, or deny the application. So once the decision has been made, if it's for the planning commission, it will go to the board in a kind of a similar fashion, and the board will make the final decision. And then once the final decision has been made, there will be an effective date of the approval. There's a possibility for an appeal if the application was denied. If there are modifications to the approval that are required or requested by the applicant afterwards, generally that's another land use application for an amendment. There are also dates that we want to track. Some of the approvals have expiration dates. They don't, like if you get a site plan approved for developing a restaurant, you have to get your building permits within a certain amount of time. Otherwise, that entitlement, that approval expires. It can't just go on. And usually they're about 1 to 2 year lengths of time for those approval dates. Once the building permit is issued, which is kind of the final step in this, then those expiration dates don't really matter anymore, because then the expiration dates on the construction of the site or the development of the site are then left to the building permit expiration dates. And just a note on here, I don't know if all of you are aware, but the Pikes Peak Regional Building Department serves as the town's building official. So this was the slide I was talking about previously, which I stumbled a little bit. Decisions for land use applications are not always made by the board. Minor site plans, temporary use permits, and minor modifications can be made by town staff. And that would include planning staff with the assistance of engineering staff, and through the review with the planning commission reviews major site plans, all kinds of both minor and major subdivisions, landmark designations, certificates of approval, and appeals of a staff decision. And then the board not generally, but the board approves this last list of items. Most of these things go to the planning commission for recommendation to the board before they go to the board. And those are conditional use permits, final plats, rezonings to PUD, land use code text amendments, and appeals of a planning commission decision.
Hey, Julie, could you explain the asterisks under town staff for minor modification?
I'll take that one.
Thanks, Ben.
Yeah, the code is not, we haven't dealt with a minor modification yet. The code isn't entirely clear on in all cases who the decision-making body is. So far, my read on it is that a standalone minor modification, let's say somebody built something wrong and there was a, sort of a minor setback issue and they needed a relief from that. My interpretation is that the staff could approve that administratively. I think, though, if there's a minor modification that's accompanying another land use application on this list, like let's say there's a major site plan, but it includes a minor modification. My interpretation would be that we would take that along with the major site plan to the planning commission to make both those decisions. Similarly, if there was a minor modification that was associated with a conditional use permit, we would take that all the way to the board, and the board would make all of the decisions related to that application. So far, that's my reading of what the code intends.
Thank you.
All right. And this screen is a little bit hard to read. This is a clip directly from a table in the land use code. And this talks about zoning districts. When purchase of property in town, like every town, it comes with the zoning district that gets assigned to it by the town. The town has 2 residential zone districts, R1, which is low density, and R2, which is medium density. There's a mixed use district, which is generally for commercial and industrial, with some limited residential options for that district. Open space is obviously for open space, parks, the natural environment, and generally for the public recreation. A PUD is a planned unit development district, and that is a district where there's no specific, it's not one of the 4 other districts. It's its own district that the developer works with the town to establish the development standards for that district and the uses. And that generally gets put together in an official document that gets recorded with the county and is approved by ordinance, because it's considered a zoning document. And then there are 2 overlay districts, the downtown village overlay and the historic preservation overlay. These are overlay districts. So if you have, maybe you have a historic home and you're zoned R1, you might also have a historic overlay. The R1 is your base zone, and all of the regulations of that zone district apply. In addition, the regulations of the historic preservation overlay also apply to that zone district. So those are kind of meant to provide enhancements or additional regulations for areas in the downtown village and other historic areas of town. And then this is just a picture of the existing town zoning map. I know this is a little bit out of date, and Becky has mentioned that it is in process of being updated, but I thought it was worth showing to you guys. The red dashed boundary is the town limits. All of the yellow is residential, and so you can see the town is made up primarily of residential zoned properties. And then closer into the highway, there are those mixed use areas as well as some open space. And that concludes my portion of the presentation, and I'm gonna hand it over to Ben.
Thanks, Julie. So land use. Probably the one of the most fundamental aspects of the land use code. Go figure. It's called land use code for a reason. It's one of the sort of the fundamental things that we look at whenever we would have a new application come in that proposes something new. Is it a use that's even allowed? Or is it a use by right? Is it a conditional use? Or is it a use that's not allowed? And that's going to be a sort of initial guide as far as what kind of process we need to follow. So this is just a snapshot right from the top of the table. This is just the beginning of your permitted uses table. And you can see up in the near the top, it tells you, it has a little legend here that tells you if it has an X in it, it's a use by right. If it has a C, it's a conditional use. And that means it's required to have a conditional use permit approved. If it has an A, it's considered an accessory use. And then T is a temporary use. if the cell is blank, that means it's prohibited. And so this goes through all the different uses. This is just going through the very first part of the residential uses. And you can see that we've got some X's, we've got some C's, we've got some blanks. As you scroll through, you'd see a lot more, variety in terms of how different uses are treated in each of the 4 main zone districts that you have. As Julie mentioned, when it comes to a PUD, the PUD doesn't appear in this table because the notion of a PUD is that you are essentially writing your own zoning. A property owner is coming in and negotiating with the town to draft a document that writes the zoning for the property. In your case, that includes land uses, all the different development standards. So you won't see PUD appear in this table. You won't see it appear in the dimensional standards table. It's all customizable essentially with the agreement and approval of the town. There are a handful of uses. You see this last column here, use specific standards. There are a handful of uses in the table that have some additional use standards that apply. And those standards come right after this table. So whenever they apply, there's a little reference to that section of the code and a link to guide people down to those additional standards that apply for that particular use. Another part of your code is the development standards. This is all of the sections that appear in your development standards chapter. Dimensional standards, very typical: lot area, lot width, setbacks, building height, density. That appears in a table. Again, for your 4 zone districts the 4 main zone districts that you have. Fences and the various regulations around fences, height, and design standards. Sensitive lands, stormwater, and drainage. Everything on this list that's listed under here is we rely on Kiowa. The town relies on Kiowa Engineering to do that review. The only one that's an exception would be wildfires. There's pretty limited standards related to wildfires, and that's a review that we do as planners. But everything else, floodplains, grading, drainage, stormwater, wetlands, that's all in the scope of what Kiowa reviews. Parking, minimum number of spaces. There's some standards about design and layout. You have signage standards, and then you have a list of subdivision standards. Just sort of layout type issues with subdivisions for the most part. And that's just a brief overview of the development standards that you have in your code that we would be reviewing applications against. And
Just
then,
FYI for the board, there is a bill up there where they're talking about where we cannot enforce minimum parking standards. I don't know if it's been signed into law yet, but it seems to be on a fast track to get signed.
So last but not least is findings. If there's one aspect of our presentation that I would want to leave you with, it would be about this, because every decision that you make or the Planning Commission makes related to a land use application, it needs to be supported by your findings on the approval criteria. That's the language of your code. That's how your code functions when it comes to land use applications. The only thing that really matters ultimately is the findings that you make relative to the criteria. We as staff are always going to come to you with our recommended findings. We're going to make a finding, and we're going to support that finding with some kind of rationale. You're not always going to agree with us, and that's okay. But just know that if you're going to make a decision that relies on our findings, it becomes quite simple, because you can just reference the findings that we made in our staff report if you're going to disagree with our findings, and especially if you're going to make ultimately make a decision that goes against the recommendation that we make, then you need to just make sure that you're making the findings the conclusions that you've come to on the findings on these criteria. It just needs to be on the record what your decision is based on. The way approval criteria are organized in your code, there are a set of general approval criteria. That's what this list is, A through F. General approval criteria that apply to every application. And so you'll always see at least this list, again, with our finding and our rationale. 3 of those, D through F, are all about adverse impacts, essentially. Adverse impacts. The first one is just whether it mitigates adverse impacts. There's a little bit of redundancy here, that it will not result in significant adverse impacts upon the natural environment, air, water, noise, stormwater management, wildlife, and vegetation, or that those impacts will be mitigated or not result in significant adverse impacts upon other property in the vicinity of the subject property, so neighbors. And so that's that's an important part of the findings that you make. There are a handful of applications where there are some in addition to the general approval criteria, there are additional criteria. This happens to be for a conditional use permit. And so these 4 items, in addition to the 6 on the previous slide, need to be a finding needs to be made on these in addition. One other thing I wanted to go back, we've processed essentially one application. We've brought one application to the Planning Commission and the town board. And one of the issues that came up in the Planning Commission meeting in particular that was a surprise to us was that the Planning Commission was concerned that we were proposing conditions of approval that exceeded their authority. And it's not something that I was prepared for, and I wasn't quite sure how to respond. But I just wanted to cover, in terms of your authority, there are certain regulations that actually appear in your code, and they're part of your code of ordinances, the codes that you've passed. And then there are things that are outside of your code that are still within your authority. And part of how that gets delivered, and what I wish I had said on the night of that Planning Commission meeting, is all wrapped up in this very first criterion, which is that the application complies with applicable requirements, including this land use code, town, state, and federal law. So there are laws outside of your code that you certainly have the authority to ensure are enforced. And a very common example of a federal law that comes up in land use cases is ADA. ADA, Americans with Disabilities Act, that includes a whole host of accessibility regulations that need to be applied locally. They don't ever, that I've seen, appear in full in a local land use code, but that doesn't mean that they don't apply. State law, one of the conditions that we talked about was referring the application to CDOT. And certainly there's state regulations that would apply when CDOT has jurisdiction of a highway. So I just want to make sure that this board, as well as ultimately the Planning Commission, will have an opportunity to communicate this to them as well, understand that their authority does not rest solely on what actually appears in your code, that this criterion actually gives you access and creates some authority and obligation to enforce other laws beyond your code. So that is the end of our presentation. The other thing that I wanted to do, and I think we've got time, is to go to your website and show you the planning and land use page of your website. And this is something that we're going to be working on to make sure that all of your various forms are updated, updated relative to, in particular, relative to your newer land use code. But so structurally, there's a lot of really good things here that I think, especially for a town of your size, to have this kind of information available is really, really helpful to the public, I think. So I'll just run through these different sections. Land use applications. The applications themselves are here and linked. So customers can come in here and actually bring those forms up and fill them out. And again, we're going to be looking over these to make sure that everything that you have here is fully up to date and works well. This section doesn't have a lot in it. The land use approval process. Julie and I talked about refining the process slide that we included in this presentation and actually providing that information here. So we'll be looking at that as well. There's a nice list of frequently asked questions about, when permits are needed, when they're needed from Green Mountain Falls versus when they're needed from Pikes Peak Regional Building Department. When business licenses are needed. This is all really good information. I think very helpful to the public. Interestingly, the vast majority of the time, if you're doing something on your property, you probably need some kind of a permit. Not always a building permit from PPRBD, but sometimes even if that doesn't apply, there is some kind of permit or process to go through with Green Mountain Falls. And then it walks through the paperless policy, trying to encourage people to embrace electronic submittals. And then there's a nice list of helpful links and resources. And I would strongly encourage you, if you want to know, just get a little bit more background about land use planning in Colorado. This last link, this is on your website right at the bottom of the list, this very last link, or actually the one above it, local government land use authority in Colorado. This is a short read. This is what it takes you to. And this is, you can see from the contents here, it's 6 pages total. I think you'll find this very helpful to sort of understand, land use planning beyond what we talked about tonight, just in general in terms of the Colorado statutes and how they apply locally. And that's all we've got. But we can definitely answer any questions you have.
Just questions in between you and a beer.
Okay, so I'm the one who raised the concerns during the planning commission. And I came out of the Federal Aviation Administration, and we were not allowed to require anything that was not specifically identified in our regulations. And on top of that, when I built here back in 2020, the engineer came back and had a recommendation that we put in a concrete pad going off the road. And I contacted the engineer about that, and I said, where's the requirement for that? He said, that's our recommendation. I said, you realize your recommendation now becomes my requirement. He then removed it, which fortunately I was getting ready to file a lawsuit because there was nothing there. And so I'm very, very sensitive to anything that is beyond our code where we're coming in and we're saying, we recommend doing X, Y, or Z.
Yeah, I mean, it's good. You basically aren't supposed to be requiring things that your code doesn't allow. You're not supposed to be putting conditions on things that that you're just requiring without any basis in your code. I think the key point that Ben was making is that your code actually does allow you to require that applicants comply with other laws as well. And if other laws require certain things, you can require that as a condition of an approval.
Yeah, but we're not a permitting authority, right? The county's the one that actually issues permits for all the structural things, right?
You're
No.
talking about building permits.
Yeah,
No, building
for
permits is
requirements.
done through Pikes Peak Regional Building Department.
Yeah,
That's
right.
not the county. That's
Well,
a-
the
it's-
county
So
handles.
Pikes Peak Regional Building Department
Yeah.
then issues permits that have the requirements that you're speaking of. Is that right?
No,
No?
no,
So
they're
what-
going to apply the building code. They're not going to apply, for instance, ADA. They're not going to require that somebody get an access permit from CDOT if it's required.
So we're enforcing CDOT
How do we do that?
standards through our permitting process in town?
If you're aware that CDOT, essentially all you're doing and what we should have done if we'd been involved in the application from the beginning, what would have happened is we would have referred the project to CDOT. We would have sent them the application and gotten their comments. And their comments would have said, this property owner is required to have a CDOT access permit. And then from there, it's up to the applicant to follow up on that and go through that process. You're not enforcing anything. All you're doing is referring the project, because if you have a project that's adjacent to a state highway, it should be referred to CDOT.
Yeah, I mean, I think that you do have requirements in your code that there's appropriate access, depending upon the type of application you're dealing with. So I think you're looking at like, there's land use approvals, like planning, which is what Ben and his crew do. And then there's building permit, like building code requirements. You have to have structural requirements and that kind of thing. And so regional building shouldn't be, the way it works is you do the land use approval, and then regional building will take a look at the, their actual structural plans. And regional building shouldn't be approving anything until you all say, yeah, it meets our planning requirements. And so they're a little different. But if you know, looking at a planning decision that, okay, property's supposed to have access is onto a CDOT controlled highway, you refer to CDOT, CDOT says, we're not going to grant access here, doesn't match your plan, then you would have to basically, go back to the applicant. So you kind of are enforcing.
So we need to put CDOT stuff in the town code, or?
No, because I mean, what Ben referenced is it has to apply with other applicable laws, rules, and regulations. And so if an application is not meeting requirements of other laws, rules, and regulations, like CDOT's requirements, then you can consider that in your approval, and you can require that it do that.
Isn't that-
Well, there's a lot of entities that we don't have personal knowledge of.
Right.
Are we supposed to have the knowledge of that?
I think
That's the question I'm at.
Well, it's a good question. All my clients generally have a list of referral agencies. They'll basically have an application and they'll say, oh, well, this is going to be a referral, comments to the fire department. They're going to refer to, it depends on the application. And they'll take the comments, and then some of them may be applicable. Some of them we're not concerned about that. And then you'll basically have the applicant say, you need to address this, you need to address that, be aware of this.
Okay, so we should be part of a checklist that we have.
Yeah,
We need that as part of the checklist.
Yeah, that could be one of your internal policies, right? Where you have a checklist of who gets referred to. So,
Yeah, it just seems to me that would be an item between the applicant and the other entity.
I guess it depends upon exactly what you're looking at, right? I mean, I'm not here to argue. I'm just saying that it's standard process, and you don't want to be approving an application for a subdivision or a lot that there's no access for. That's a standard subdivision requirement. So, and if CDOT's saying, like, for example, I'm doing that right now for one of my clients. The question is, can this applicant actually access onto a CDOT controlled right of way? And it's not clear that CDOT's going to let them do that. And so my approving authority is going to say, well, you don't have access. I'm not going to approve this application. You got to go back to CDOT and talk to CDOT and then come back to us and figure it out. You wouldn't want to be approving something like that in your town without access. I mean, that's one example. So, and some of these things, like, I have other ones where basically there's an application and depending upon the situation, they have to have appropriate, their use of the water is controlled by the state actually has a well permitting process. And the client just said, we approve the application subject to you obtaining appropriate well permits from the state. And so if they didn't say that, I think technically, they could basically maybe just continue to build whatever they want to do. And they don't have that condition in the approval. And yeah, they still have to get the well permit. Yeah, so it doesn't really, in a way, doesn't really matter because they still have to get the well permit to do the operation. Without that condition, you don't have the authority to really say, hey, you didn't get your well permit. That's a condition. So we're not going to let you, get your building permit with regional. So I don't think that it's inappropriate to refer to other requirements if it is relative to your criteria.
But if we were to come out and say in that case with the well, you meet all of our codes, go deal with the water. Here's your town approval.
Yep.
You meet all of our codes.
Well, if the code doesn't require water, right?
Yeah.
Yeah.
Yeah, assuming the code doesn't
Yeah.
require water.
Right,
Well,
right.
it's
Yeah.
conditional upon the building department issuing the permits and everything is after that, right? They have to start with us.
Yeah, and so I think that, the building department's not gonna look at certain things you're gonna look at, right? So I mean.
Right.
Yeah, yeah. But the building department's not
we-
gonna say,
I guess what I'm saying,
Yeah.
without saying it, is are we replicating processes already or?
I guess it depends upon, like, for this example, I'm gonna use the example of whether you have access or not to your property. So if you basically look at the subdivision or whatever development application for this lot, and you don't care if they have access or not, so say you prove everything, and you're not really concerned about whether they have access or not, I'd argue you should be. They're gonna go down to regional, and they're gonna get that permit. They can go ahead and start building.
Mhm.
They can build that whole thing. You've approved the project. They're in compliance with your rules. It's all done. Guess what? Nobody can get to it. That's not good for you. That's not good for them, not good for the town. I mean, it's good to refer, and then I guess based on the comments to decide whether or not it's something that you basically want to put in your permit or in your approval based upon what exactly the issue is. So,
Just FYI, in this specific case, there's already access off the highway.
yeah, I mean, I don't know the details of this case, honestly.
It's been there for,
I think
As long as
that
we
we're
can-
really talking about here is, what does your code specifically need to list as a requirement? And I think the concept, you're totally right. That you cannot be just making stuff up because you like to see it, right? But I think there's also, it's kind of a concept that doesn't have to be specifically stated that if it's encompassed within another criteria. Like, for example, it's encompassed within, you must be in compliance with all their laws, rules, and regulations. It doesn't have to say CDOT regulations or CDPHE regulations. You could basically reference that and require it as part of your permit. Some of my clients honestly just put like a standard statement, every single application they approve, subject to compliance with all their legal requirements. And then that way they have enforcement authority based on their approval. And they don't have to they can't just say, oh, well, we didn't put it in there and hopefully they'll figure it out later.
Well, I think we have something like that, don't we? Pending approval by,
I'd have to look at our
Yeah.
applications.
okay.
Yeah. And I think it's probably, if you know there's a requirement, for example, this is required, like specifically, I guess my thought would be, why not put it in there? Because that's a requirement. But if you don't want to deal with it, and you're like, well, we don't care that much, let's CDOT deal with that, then you don't have to.
that's my opinion. We don't, and where I get in the issue with it is us getting in between an applicant and CDOT, where we're in between, and I don't want to be there. To me, that's the applicant and CDOT in this specific case issue. They need to work that out. There's already access there. If CDOT's going to come back and say, no, you don't have adequate access, that's between the applicant and CDOT.
Yeah, we'll have others like the fire department will say you have to have dual access. You can't just have one entry, one exit. It has to be so wide for this truck.
Right.
And then you could say like, well, we don't care. And you can approve it. And then you have a situation where the fire department is going to basically not issue their approvals.
Yeah. Fortunately, in this case, if it really came to shove, they could get another access through another point on their property.
Yeah, I
Really
mean,
want
but this is more of an example. My point
Yeah.
is that like, it does make sense to refer, it does make sense to consider the referrals. And it does make sense in some situations to require that they comply with the other agency's requirements. Because ultimately, you have the authority under the general provision. And ultimately, you don't want to be approving applications and projects that can't operate appropriately or that aren't safe. And I think that it's tough to have every little detail in there. You know, it's just, it's more of a policy. I'm not saying you're wrong. I'm saying there's probably a balance there. You know, what makes sense, what doesn't make sense. But I think the question was, do we have authority to do that? And I think you do. Whether you want to or not, that's another issue.
And
So-
the other point I'd just like to make is that issues on projects, whether it's access, utilities, anything else that we would refer out, if we put off and we just let the applicant go deal with CDOT, each one of those things, depending on what the outcome is, like the worst case scenario is what Jeff described, they don't get access at all. Maybe that's unlikely in this case, because there is an existing access. It just hasn't been used, and it hasn't been used in this way. So I can guarantee you that CDOT would say it needs an access permit. But it can have a domino effect. I mean, there could be some improvement that then impacts an improvement that you've approved. And then you're forcing the applicant to potentially come back to amend a plan that you approved because they discovered two or three different issues that had to do with other agencies that now affect their plan, and they need to come back and fix it. It's just not a very efficient process to not consider all those issues that can impact the plan up front.
So here's another question. So Ben, is Baseline got two customers? Is the applicant a customer as well as Town of Green Mountain Falls? And what I mean is the communication to the applicant through Baseline and not through enforcement by Green Mountain Falls?
I mean, I'll answer that on Ben's behalf, and Ben, you can tell me if you think differently, but I think the question really is like, who do you serve? You know, whose interests do you serve?
That's what, yeah.
And I think
that's
they're
what
like,
I'm
you know,
getting
like the client of Baseline is the Town of Green Mountain Falls. They pay the
at.
bills.
Is it the sole? But and
Sole-
because we've already got this shared use fee schedule, you know, like,
Yeah,
so, but it's.
doesn't
through-
matter.
Okay.
Yeah, so I mean, so I think it doesn't matter who pays the bills. So a lot of my clients will do like cost recoveries, and like, you know, developers will pay the costs of the consultants. That doesn't mean that the consultants work for the developers. They protect the town's interests. But I think that, you know, the flip side of that is that Baseline should be considering what's the most efficient, most reasonable way to get the applicant, what the applicant's looking for, give the applicant advice. Hey, you know what? Town doesn't allow this and allows that. They shouldn't just be like, no, follow all these super hard requirements. You'd be thinking, hey, here's an easier way to get things done. That's what you want from good planners, because developers, residents, you know, ultimately they're people who like the town wants to serve properly, but they also have this balance. I seriously think being a planning director is the second hardest job in a town behind town manager. I mean, you just get beaten up left and right no matter what you do. So it's really hard to find that balance where you're basically helping people do things they want to do, but not letting them do things the town's codes don't allow. And it's one of these things I can see, you know, Trustee Ives here it's one of these things where, you know, a lot of people feel like, oh, they're just making me jump through all these hoops. This is ridiculous, these requirements, you know, these are ridiculous. So part of the thing we've done with the town code is try and make it a little more streamlined, a little easier to apply, less hoops to jump through, and maybe there's more we can do. I mean, I'll tell you right now, though, your code's not any different than a lot of my clients. It's not any particularly especially difficult, but these are the complaints I hear all the time. You're making this too hard. So I think they're the town, they serve the town, they're supposed to be applying town criteria, but they should be looking for ways to make it easier for everybody to do business. I hope that's a long answer to your short question, but that's the way I see it.
Yeah, I would agree. I mean, we definitely serve the town. I'm not sure I always distinguish between the town and its citizens. The town sort of is its citizens. So, and that's who most of our customers are. They're not, especially in a small town like Green Mountain Falls, they're not outside developers coming in and doing something in the town. For the most part, our customers are your constituents who are your citizens.
The easiest job is to be the town attorney. That's easy. I just tell you what the law is. That's easy. But no, I do sympathize with everybody who tries to handle these sort of issues on a day-to-day basis. I mean, they really are tricky, and you know, it's a balance. I'm not trying to. I felt like I was kind of arguing with you all up there about, you know, the ability to enforce other requirements and codes. And it's kind of a policy choice, and I think there's a balance, right? You don't want to just be like putting every single possible thing in your permit requirements when it's going to get addressed, but it really does. Part of the job is say, hey, here's some issues you're going to be seeing. Hey, make residents, most of them aren't sophisticated developers, right? You know, make sure you look at this, like, because I don't want to have you come back and then change everything because, you know, you got to move your entrance from here to here and everything changes. And so that really is a good point, but that can also be looked at like you're making us do all these extra hard things, right? So I get it. So
I don't think anything's hard. It's not that. There's different entities that have different responsibilities and we have our responsibilities and what we're trying to look out for. There's other departments that have their responsibilities and it's the end user that's going to end up dealing with all that stuff, whether we put it on a checklist or not. CDOT sees somebody doing something off their highway. I assume they're going to have interest in that. If it's something that's wrong, isn't that true?
absolutely.
Yeah, I have no idea what CDOT's enforcement level is when it comes to their highways. They have a lot of highway and a lot of things could potentially be happening without their approval. I have no idea what their enforcement looks like.
I do know people find out later.
Yeah.
Yeah. Yeah. And it's a huge problem sometimes, right? Versus finding out up front when it's not as much of a problem. So
They tend to pay pretty close attention to what's going on their highways. I mean, they do. If somebody puts in an access or something, they do pay attention to that.
So there was, where do environmental studies fall into this since we're, you know, there's a lot of environmental state laws that we may or may not be aware of. How is that process reviewed in this?
Um, there aren't. Let me see how to answer this. There are not substantial state environmental laws that apply locally to most land use applications. There are definitely some in unique situations where you've got, you know, underground tanks or, you know, you've got certain kinds of land uses that have potentially created environmental impacts.
How about a gold, you know, a gold mine, a mining shaft?
Sure. Do you have a gold mine in Green Mountain Falls?
Yeah, I'm not going to tell you where it is though.
Okay.
It's a fake one. They plugged it up a long time ago. It's still there though.
Well, the point is, you know, when are we supposed to be aware that an environmental study is supposed to take place, if ever?
I mean, we would be looking at your code for the most part. There's occasions where we might, especially in the case of an annexation, we might refer to Colorado Department of Health. There are definitely state agencies that we can refer projects to, and just sort of getting back to your referral list. That's something that we do in the communities we serve all around the state. So we're quite familiar with all the different agencies and the contacts there, and we can certainly help you develop a list of referral agencies that and you know, have some criteria for when projects should be referred to them. But for the most part, if unless there's something in your code, which I'm not aware of, you know, there's not a requirement for an environmental impact report for most of your land use applications.
Yeah, the only difference may be, we do have two creeks that do cross some private properties. And I know on the public property side, we have to go to the Army Corps of Engineers if we're doing certain things. And there's also Fountain Creek watershed that may have to be dealt with. But those are probably the two more likely scenarios that we might get hit with, is either Catamount Creek or Fountain Creek, and where they cross private properties, and if they want to do modifications or do something that crosses the creek, so to
Mhm.
speak.
We
Yeah,
also have that Cristola Creek,
The what?
the Cristola Reservoir Creek.
Crystal, yeah.
Yeah.
It's Crystal, Catamount, Fountain.
Crystal.
Those would be the ones that would be more likely to come up on maybe a land use application for us.
Well,
Yeah, I mean-
oh,
Go ahead.
sorry, Ben, I was just gonna reference to like when we did our FEMA project. That triggered some FEMA review and they did come out, they had an environmental inspector come out and determine whether or not we had to go through environmental permitting. So there's several things that trigger that higher level of an environmental review depending on the project.
Yeah, and so wetlands, that's essentially where FEMA comes in. If you're going to modify or impact a wetland, then you're going to go through a permitting process through FEMA. And as the mayor mentioned, U.S. Army Corps of Engineers gets involved in impacts to navigable waters.
Looks like questions are dwindling. Anybody have any final points they want to make, final questions? Ideas for some deep dives? I'm sure that they'll come up, that you don't have to let me know now, but send me an email. Speaking of emails, was everybody able to get into their new town domain email account?
Yeah, although I gotta admit, it's not auto forwarding.
It will not auto forward to an outside, but you can auto forward your Gmail to it.
Yeah, I was looking for it to do it the other way around.
Yeah, unfortunately, we investigated that option, and it just didn't, it unfortunately didn't work. So if you need a, crash course in Outlook, any of its features, let me know. Happy to help there. That was the end of my lists. Unless you guys have anything else. Was this valuable? Did you learn something tonight?
Yes, thank you very much.
Okay, good. Thank you, Ben and Julie. Appreciate you being on, staying up late with us.
Thank
Thanks,
you.
Becky.